Let's talk about the Amazon documents. Click data. I could probably testify as an expert for clicking on Amazon. Sounds like they're going to explain it. Okay, so they are concerned about the way the prosecution is going to present this. So they don't want to show the information to the defense. They just want to get it in front of a jury. Welcome to Typically Unique. And today I am going to read the Amazon click activity document. Let's get into it. Comes now Brian C. Koberger by and through his attorneys of record and hereby replies to the state's response to defendant's motion in limine number 9 regarding excluding Amazon click activity evidence at trial filed on March 17th, 2025. And that was the state's response. This reply is supported with the declaration of David Howell as the court issued an order prohibiting expert testimony in support of this motion. As the court issued an order prohibiting expert testimony in support of this motion, absent a specific need identified by the court during the hearing. So there was an order denying witness testimony on April 9th, 2025. Okay. Filed March 18th. The court has instructed Mr. Koberger to have his expert available via video live stream. Okay, so we read the call detail record, I think it was, document where Cy Ray gave his affidavit and is not expected to testify. And then it sounds like when it comes to the Amazon information, there's a expert that has to do the same thing. For the first time on March 14th, 2025, the state provided an expert disclosure of opinions of Shane Cox and federal agent Michael Douglas regarding their opinions related to Amazon records. And then it says, see state's expert disclosure March 14th. And I looked at that and it was just the 2-page document where they just file it. This is an example of abusive discovery tactics by the state. There is a pattern of failing to disclose evidence and expert opinions in compliance with the court's order. Okay, then they cite the motion to compel material and for sanctions filed December 27th. These prosecutors blow past deadlines and respond after it is brought to the court's attention and after they have the benefit of having Mr. Koberger's expert opinions. The state's expert disclosure is 3 months past its deadline, with trial looming in less than 5 months. And then it says redacted order governing further criminal proceedings and notice of trial setting filed October 9th. Mr. Koberger seeks to protect his rights to due process, effective assistance of counsel, and a fair trial guaranteed by the 5th, 6th, and 14th Amendments of the United States. All right, here's the argument. The state seeks to use expert testimony to show that a very narrow set of Amazon records of purchase and click history related to a K-bar knife and sheath makes it more probable than it would be without the evidence that the K-bar knife sheath found at the crime scene was Brian Koberger's, and that click activity after the homicides makes it more probable than it would be without the evidence that Koberger had a reason to search for K-bar knife and sheath after the homicide. All right, I got to look at this purchase one. What did that say again? The state seeks to use expert testimony to show that a very narrow set of Amazon records of purchase and click history related to a K-bar knife and sheath makes it more probable. Okay, so here's how I'm trying to wrap my head around this. If you're saying somebody bought a knife sheath, and say they bought a knife sheath and produced the receipt, and if it was at a store, you could have video images, but on Amazon, you have your whole account is digital on there. This is, oh my goodness, I don't know why they're wording it this way. And then to say makes it more probable. I don't know. It makes it, I would interpret this that they don't have a receipt, or they don't have the actual information from Amazon. And because why would you need somebody to come testify to that? I don't know. I guess we'll find out when this is going to be one of the things they talk about on the 9th. Okay, so they have a narrow purchase history that is showing a probability, and then they have click activity. So it looks like he was clicking on knife sheaths after the crime. Asserting that lay testimony would be appropriate for these issues, the state claims that Mr. Cox is not needed as an expert because the Amazon records speak for themselves. Okay. It claims the expert disclosure is given in an abundance of caution on its part. In a separate motion, the state seeks self-authentication of the Amazon records. As set forth in Mr. Howell's declaration, Amazon data is complex. There is nothing about its production, review, or analysis, algorithm, or machine learning that a lay witness could explain to a jury. Without proper expert explanation, the data itself is misleading. This is so weird. I mean, like, a receipt is a receipt with your address on it and your web and your email. Especially incomplete and cherry-picked data, as is the case here. Okay, so this is the defense speaking. So it sounds like the state wants an expert because of how the prosecution is going to come in with this information. So it sounds like they're afraid of the way, not afraid, but concerned that the way the prosecution is going to present this to the jury, that the defense wants to be able to have a witness there, to counter what they say, or the lack of what they say, if they can come in and show more information. And then it says, not only did the state fail to properly disclose the evidence and expert opinions, but it also advises that it is awaiting additional information from Amazon that the state understands will clarify that to the extent AI is incorporated into Amazon's system, AI does not create a user's actual inquiry. Apparently, more late discovery tied to expert opinion is coming. That doesn't sound like very certain evidence. It sounds like they're going to interpret something that AI is, or the computer software, using AI is going to produce. Of note, Mr. Koberger sought to suppress the Amazon search warrants as overbroad and general warrants because of the extensive amounts of records requested. This court denied that motion. Now that the state has disclosed expert opinions, it is clear that the state intends to use incomplete data and mislead the jury. Okay, so they are concerned about the way the prosecution is going to present this. For example, the state ignores that the Amazon records reflect a household of users on the Amazon account at issue, and a long list of items purchased over a period of several months for a road trip or hiking, to include a roadside repair kit, a tire inflator, a backpack, and bear spray. This sounds like they're going to explain it. The state argues that the rule of completeness does not apply, and therefore it is appropriate that limited information about Amazon be placed in front of the jury. So they don't want to show the information to the defense. They would just want to get it in front of a jury. Am I reading that right? This argument ignores and violates Mr. Koberger's right to present a complete defense. As Justice Potter Stewart wrote, any rule that impedes the discovery of truth in a court of law impedes as well the doing of justice. Yeah, he has the right to see the evidence. Allowing the state to produce limited data without context and the methodology of how Amazon works is akin to telling the jury that it may assess the product of an investigation, but that it may not analyze the quality of the investigation that produced the product. That fits into so many aspects of this case. This illogically removes from the jury potentially relevant information. And then it says details of the investigatory process potentially affected. And then it says the investigators, credibility, and perhaps more importantly, the weight to be given to evidence produced by this investigation. And that just cites the case that quote is from. Mr. Howell explains the critical need for full data and an understanding of what it means to click on Amazon. Click data. I could probably testify as an expert for clicking on Amazon. Click data sounds like a specific user action, when in fact, Amazon's algorithm, machine learning, and methods of paid advertisements force information to account users, which fall under the definition of click data. Features like customers also bought, frequently bought together, omni-channel influence, and household accounts with multi-users have a significant impact on what is considered click data. Amazon notifies users of items bought in the past as a reminder, which can be interpreted as click data. Logs of this data are retained by Amazon because Amazon bills its advertisers. All right, here's the conclusion. I'm not sure I understood any of that. They're just, I don't know, talking about the technology. For the reasons addressed above and in his initial brief, motion in limine number 2 to exclude expert testimony, the details in the expert disclosure of Mr. Howell, motion for leave to call him as a witness, and the declaration of Mr. Howell, Mr. Koberger respectfully requests this court grant his motion in limine to exclude any Amazon and Amazon Click activity evidence. He renews his request for live testimony by Mr. Howell on April 9th or 10th. Should the court allow the state to continue in its abuse of deadlines, there's no arguing that, and incomplete expert disclosures by allowing this evidence, Mr. Koberger seeks to confront the Amazon evidence at trial with the testimony of Mr. Howell. Okay, so they want to get him on the stand on the 9th or 10th, get him to enter on the record his testimony, and then be able to use that at the trial. That's what that sounds like to me. All right, and then what is this? This is, oh, here is David Howell's declaration. So he has his qualifications. I am the founder and principal of Howell and Associates, a firm specializing in brand protection, e-commerce channel compliance, digital forensics, and online marketplace analysis or analytics. I have more than 20 years of experience in the e-commerce ecosystem with a significant focus on Amazon's marketplace. I have worked with national and international brands in evaluating threats, fraud, and marketplace manipulation involving Amazon and other major platforms. My work includes investigating counterfeit activity, digital behavior, diversion, unauthorized sales, channel management, violations, and identifying algorithmic manipulation across e commerce platforms. I am regarded in the industry as an expert in online marketplace data analysis and forensic evaluations of digital purchase behavior. Artificial intelligence, for the purpose of this declaration, refers to systems that simulate human intelligence by making predictions and decisions based on user data. Machine learning refers to the subset of AI that enables these systems to improve over time through exposure to new data. Both AI and ML are core components of Amazon's internal recommendation systems, search result algorithms, advertising delivery, and behavioral targeting tools. My firm regularly analyzes Amazon data to uncover fraud, track user behavior, and interpret system-driven changes in product visibility and recommendations. Our work is focused specifically on Amazon because it's the largest online retailer, and our clients face daily challenges with how their products are promoted, represented, or counterfeited through its ecosystem. I have reviewed the materials produced by the state in this matter, including Amazon clickstream and purchase records, as well as expert declarations and summaries submitted by state designated experts. I have also reviewed the motion in limine filings related to Amazon data. So this is clarifying click data. The state refers to a portion of the Amazon records as click data. While this terminology may suggest a comprehensive behavioral log, it does not reflect the depth or complexity of how Amazon tracks user behavior. In reality, a click on a product listing is just one visible output of Amazon's AI driven and advertising based system. Okay. In reality, a click on a product listing is just one visible output of Amazon's AI driven and advertising based system. These clicks are influenced by recommendation algorithms, sponsored ads, cross device history, retargeting behavior, and account personalization, all of which shape what the user is shown before they click. My expert opinion is that click data as presented is only a surface level snapshot. It must be understood as part of a broader ecosystem of behavioral inputs and algorithmic outputs. Without the accompanying data, such as recommendation logs, ad exposure, keyword bidding records, and ranking logic, the click data is not forensically complete or contextually sound. So it sounds like the state is saying Brian did something on an Amazon account that makes it look like um, he clicked. And this guy is going to say, not necessarily so. Omnichannel tracking and multi device activity. Amazon synchronizes user activity across multiple devices and platforms. Activity from a phone, laptop, smart TV, tablet, or even third party apps is integrated into a single behavioral profile. This cross device tracking influences what products are shown, which ads are delivered, and how recommendations are prioritized. If the data provided does not include metadata or logs from multiple devices used by the user or distinguish between them, then the resulting data set is necessarily incomplete. So it sounds like he's saying if you share an account and then you have multiple devices, it would really take some work to track why the clicks are showing up from who, what device, something like that. Sponsored ads, AI recommendations, and clickstream retargeting. Amazon search results and product recommendations are driven by sponsored advertising paid for by brands and sellers, frequently bought together, and customers also bought placements, AI generated product suggestions based on past behavior and similarity clustering, retargeting campaigns based on prior engagement both on and off Amazon. Amazon's ad platform operates on a pay per click and commission basis. This structure requires Amazon to retain click and ad attribution data for billing purposes. If advertisers are billed for these interactions, logs of them must exist. The absence of this data is in the state's production indicates it is incomplete. It is not technically possible for Amazon to function as a PPC platform, pay per click, without storing the data necessary to verify ad delivery and performance. Therefore, I assert that Amazon retains more data related to this user's behavior than what has been disclosed. Okay, right there, that's the point. So, Amazon has more data than what the state is intending to use and has shown so far. Amazon accounts are often used by multiple individuals in a household. Search, click, and purchase histories are generated by numerous users across multiple devices. Without clear device IDs or session segmentation, it is not possible to attribute activity to a specific person with forensic certainty. Historical data and narrowed time frame. The data set produced appears to begin in March 2022 and end in November 2022. So the March before the crime and then the month of the crime. Amazon's AI systems use historical behavior to inform present day recommendations and search results. Recommendations shown in November may have been shaped by user activity months or even years prior. By cutting off earlier data, the system's output becomes decontextualized and misleading. That's interesting. Based on Amazon's own public facing documentation, its advertising platform structure, and my extensive professional experience, it is my expert opinion that the data set produced in this case does not constitute the full extent of data Amazon retains on this user. Certifying this data set as complete is misleading unless clearly limited to a subset. Amazon collects and retains far more. No forensic opinion about intent or user behavior can be accurately rendered from this incomplete data set. Supporting documentation and citations. The following documentation confirms that Amazon collects, tracks, and retains data far beyond basic user search and purchase logs. Amazon Attribution Overview explains how off-platform ads are tracked and linked to Amazon conversions. Amazon Sponsored Products Overview confirms ads appear in search results and rely on click and conversion tracking. Amazon Personalization and AI Recommendations demonstrates Amazon's use of AI to customize product visibility. And then they have the details. Amazon retargeting and cross-channel behavior details how Amazon serves ads based on user activity across devices and platforms. AWS Machine Learning blog. Technical breakdown of how Amazon uses ML to rank search results and drive behavior. These resources listed in the paragraph above, 1 through 5, validate the statements made in this declaration regarding Amazon's behavioral tracking, ad targeting, recommendation systems, and retention practices. I declare under penalty of perjury under the laws of the state of Idaho that the foregoing is true and correct. Okay, so now I understand. So the state gave the defense the Amazon evidence way late. It sounds like they filed it earlier, but then the defense didn't get it till weeks and weeks later. And then when they did get it, it's vague and not everything that they could have gotten from Amazon. So I wasn't understanding the need for the expert testimony at the beginning, but now I see the defense wants to bring in their own expert to counter what the state is doing. So, and this is the second at least second, maybe third or fourth topic for this April 9th hearing where they are doing that. Okay, this was interesting. I was curious to see if it listed specific items, but we didn't get to see that in this one. I have heard, so I'll have to look and dig to see what other document it's in, but I've heard people talk about a face mask being purchased. So I'll look for that. And I am going to continue to read more of these documents. So I hope you will join me back for that. See you then. Bye.